Hello and welcome to our discussion of the future of data flows and the U.S.-EU Data Privacy Framework. We are thrilled to have a terrific live audience today for our discussion, our guest speakers, our keynoter, and our panel. And we're also thrilled to be joined by so many of you online who can participate in the discussion using the chat screen online and make it an interactive discussion as well. And you can also participate online using your favorite platform and the hashtag dataflows. My name is Jason Oxman. I'm the president and CEO of ITI, the Global Trade Association of the technology industry. It's my pleasure to be your moderator today for our important discussion. And we are proud at ITI to represent the world's most innovative technology companies. And the discussion today of the important tech policy issues facing the EU and U.S. relationship is vital to the future success of the innovative products and services that ITI member companies launch. So we're pleased to have an opportunity to bring this discussion to you today and hear directly from the decision makers who are at the forefront of the decisions that must be made. Now, as everyone knows, last month the European Commission released its draft adequacy decision to implement the EU-US Data Privacy Framework. Now, this is taking place under the auspices of the GDPR, and the framework, which was first outlined by President Biden and Commission President von der Leyen in March of 2022, is designed to replace the Privacy Shield regime that was overturned by the European Court of Justice. This is an enormously important undertaking, not only for the technology industry, but truly for all industries, for all business in Europe and all business in the United States. And the reason for that is data flows between the US and the EU are truly the most important in the world. It represents a $7.1 trillion market and implicates 16 million jobs between the US and the EU. So it is no exaggeration to say this is a vital economic undertaking as well as a policy decision. Now, ITI has led the call for the US and EU decision makers to reach a new data agreement that has been reached and is in the process of being implemented. It is important that this agreement both strengthen the privacy rights of EU citizens and US citizens, but also unlock the true potential of the digital trade relationship between the US and the EU. The new data protection framework is the product of the shared transatlantic values and the commitment to the relationship between the EU and the US. We know already that significant changes have been implemented to US law, including, importantly, to respond to the European Court of Justice, far-reaching and binding safeguards on U.S. signals intelligence activities, and also ensuring that all EU citizens have new, binding, and clear and effective avenues for redress if they feel as if their information has been improperly used. So the framework really reflects the joint ambition of the U.S. and the EU to work together, and we look forward to its swift implementation. Now, to discuss this process, which, as I mentioned, is still underway, the EU is in the process of validating the work that the United States government has made to put new laws and new processes in place. We have a fantastic panel of speakers with us today that I'm excited to have. You'll hear in just a few seconds from the European Commissioner for Justice, Didier Reynders. You'll also hear later from His Excellency Mark Gittenstein, who's the ambassador of the United States to the EU. You'll also hear from the Director General of the Irish Enterprise and Trade Department, who is leading the Irish government's response to this measure, and leading industry voices as well as we discuss the implications of the data privacy framework and the way forward. We'll also, importantly, make this an interactive event by having a Q&A session. So you'll be able to, our live audience members, and those of you who are participating online, to ask some questions of our panelists today, which we look forward to. You'll also have the opportunity to respond to poll questions, which we will present for both our in-person and live and online audiences to address. You can submit your questions if you're online using the chat function from Slido that's on the right of your screen. Those of you in the audience here today, and it is a packed house here in Brussels, can also use the QR code that's at your chair to open Slido and make sure, please, to offer us your name and affiliation so we can identify you when you ask your questions. And now, without any further ado, I have the great honor and pleasure of introducing our keynote speaker, who is European Commissioner for Justice, Didier Reynders. Our keynote speaker today has the important task of upholding consumer protection and the European rule of law, and ensuring that justice and rights and protections of all European citizens are upheld during the vital digital transformation that's taking place here in Europe. Commissioner Reynders has an impressive background and an impressive political career that includes his role as Belgium's Deputy Prime Minister and also service as Minister of Foreign and European Affairs here in Belgium, Minister of Finance, Minister of Defense across, and your work extended across 6 of Belgium's government mandates, so certainly an impressive career. But for purposes of our discussion today, Commissioner Reynders also plays a key role in moving forward the U.S.-EU data protection framework that we've been talking about, the EU adequacy decision that's in process, and we are delighted to have you here at work, and also where we are in the process of moving it forward. So Commissioner Reynders, without any further ado, and our thanks for being here today, I'll turn it over to you.
No, thank you, and good afternoon. It's a real pleasure to be with you today to explain where we are in such a discussion with our U.S. counterparts. And of course, you said I was doing 20 years on the other side of the street around the table of the Council, doing 40 different presidencies. But now I'm the Commission, and to be honest, I have started at the beginning of this Commission, the mandate of this Commission, to discuss with my U.S. colleagues in December 19 about a possible decision of the Court of Justice concerning the Privacy Shield. And then we have had the decision, and then we have discussed during a long period of time. And like you said, on the 13th of December last year, we launched the adoption process for an adequacy decision on the EU-US Data Privacy Framework, the DPF, so the new name for the moment of the Privacy Shield, but it's very clear, a Data Privacy Framework. And as you know, the proposals follows, but also more than that, builds on the decisions taken on the US side. So builds on the adoption of a new executive order by the US President, together with a regulation by the Attorney General. And these instruments, like you said, implement the agreement in principle that was announced by the 2 Presidents, von der Leyen and President Biden, in March into US law. And so it was very important to see what kind of new instrument it was possible to have in the US law before to start our process. And they are the results, I said, of 1 year and a half of intense negotiations. I was in the leading role on the EU side to discuss with, on the US side, Gina Raimondo as Trade Secretary, and the Attorney General, Mary Garland. And we have had intensive discussions in different places, Washington, but also in Europe, about that. And to be very concrete, and I've explained that from the beginning to my US colleagues, my mandate, the mandate of the Commission, was the Schrems II decision of the Court of Justice, because it's a decision of the highest court in Europe, so like the Supreme Court in the US. Of course, we need to take care of all the requirements of such a ruling coming from the European Court of Justice. And this is reflected in the executive order adopted in the US by the US President and accompanying Attorney General regulation. Addresses the concern raised by the Court of Justice and brings significant improvement to the Privacy Shield. I will say that it's totally different, if I may, from the Privacy Shield. We have tried to build something totally new with the US administration, and I'm very proud that it was possible to make such a lot of progress, and certainly to put difference in the new text in comparison with the Privacy Shield. I said, first of all, the executive order creates new rules that regulate how and under which conditions US intelligence agencies can collect and use personal data transferred from the European Union. These safeguards are binding on all American intelligence agencies and ensure that any access to data will be limited to what is necessary and proportionate to protect national security. And so we apply the 2 main principles about the access to the personal data, the necessity and the proportionality, and it explained how it's possible to conceive those rules in the different US texts. And these are also enforceable, like you said, because a European will be able to invoke them to obtain a redress. So it's not just an obligation for the intelligence agencies to have full respect, but it's also possible to enforce such a kind of rules with a real access to a review court. This is very different, I said, from what we have seen in the past, because before the Court of Justice, to be very concrete, the main discussion was about the ombudsperson. And in the Privacy Shield, the ombudsperson, it was established within the US State Department without own real powers. Now we have changed that, and now individuals will have the possibility to turn to an independent tribunal free of charge if they consider that their data was unlawfully accessed by US intelligence agencies. And the new mechanism will include an independent data protection review court that will have the power to investigate such complaints and issue binding decisions. Of course, it was very important to us to be sure that at the end of the process there is a real decision with a binding character for all the different actors. These are all significant improvements which allow us, as detailed in the draft adequacy decisions, to conclude that the new framework meets the court's requirement, because in the requirement of the court, it was possible that the power of such a new court includes the power to order remedies, such as, for example, the deletion of data that was unlawfully collected. And so you have different elements to show that we are far from the previous situation. Importantly, the safeguard that we have put into place will apply to all transatlantic data transfers, not only those based on the future adequacy decision. So also if you use other kind of instrument to organize data transfer, it will be possible. That means that such use of such standards, contractual clauses, or binding corporate rules will benefit from all the safeguards that we have put in the new system. This should significantly increase, of course, legal certainty and stability for EU-US data transfers. And this leads me to maybe the last point that I would like to make in this introduction of your debate, which are the next steps, because it's a long journey. I said my first discussion was in December, to discuss about a possible decision of the court, and then we have taken into account the decision, and then we have started with the new administration a long negotiation process. But all draft decision has been transmitted in December on our side to the European Data Protection Board for its opinion, which we expect to receive by the end of next month, by the end of February. After that, we will need to obtain a positive vote from member states, so we will go to the so-called EU in Brussels comitology, so to discuss with all the member states and to have a positive reaction. And of course, a draft adequacy decision is subject to the scrutiny of the European Parliament during the whole process. Once this procedure will be completed, the Commission College will be able to adopt the final adequacy decision. And as you can imagine, it is difficult to give a precise timeline, but we have a certain experience because in the last 2 years, we have taken some decisions about South Korea with an adequacy decision, but also due to the Brexit, it was needed to discuss about 2 adequacy decisions with UK. And when you look to the process for those adequacy decisions, it was needed to proceed during around 6 months. So to be very prudent, I will say that it's possible to conclude before the summer. You know that for the Commission, the summer starts in August. We work till the end of July, so we will see if it's possible to conclude before such a kind of summer. No, but we are on a good process, and the timing will also depend, of course, on the implementation of the data privacy framework on the other side of the Atlantic, because we have a lot of things to do, I said, before to go to a final decision of the Commission. But the draft adequacy decision clearly states that it will only enter into effect once the new legal framework is fully in place on the US side. And so there's also a clear message I heard from the Open Data Protection Board a few days ago when I joined their plenary meeting. I've explained to the data protection authorities in Europe and the board our new system. And of course, it was very clear that we need to have a full implementation on the US side of the actual executive order and implementing act from the Attorney General before to go to the end of the process. As required under the executive order, the US intelligence agencies will have to operationalize the new safeguards by reviewing their national policies and rules. So it's important to see the evolution in the intelligence community on the US side to comply with the new system. And similarly, the US has to designate the European Union and maybe more the European Economic Area, so with Norway, Iceland and Liechtenstein, as an organization that can benefit from the redress mechanism. It's a clear decision of the Attorney General to designate states or organization. In our situation, it's an organization because we organize the process for the entire European Economic Area. Without that, Europeans will not benefit from the redress rights we have negotiated, and thus a key requirement of the court's case law will not be fulfilled. And before concluding, let me come back to the significance of this transatlantic cooperation. It was a long process, it was a long journey, and we are not at the end, but it was very important to go to a final agreement to show that it's possible to find a way for such a kind of agreement. The intense discussions with our US counterparts have allowed to reach a common understanding and solve difficult issues that involve a delicate balancing between privacy rights and national security needs. And I know that the national security policy is a real one important policy in the US. It's become to be decade after decade more and more an important policy issue also in Europe. But it was needed to understand better the situation. This once again showed that even on some of the more sensitive issues, the European Union and the United States can work together towards positive solutions and to the benefits of both citizens and the economy. You have mentioned the figures about the economy. It's not only a protection of citizen rights, it's also a possible development for the economy, and it's also a possible normal use of some investigative measures for the intelligence agency, because we are not against, of course, a real national security policy. It is certainly a promising precedent to address other challenges of the digital economy involving equally complex issues. I will say that you know that we are working since some time on different new legislation at the EU level, the DSA, Digital Services Act, or the DMA for the markets, but also I'm working more on AI and certainly also the civil liability dedicated to AI. But we have seen that it's possible to move in some situation in the same direction, not maybe with the same kind of regulation, but the same kind of concerns. And I'm sure that here we have a good example of what is possible to do if we want to continue to work. Maybe one day we'll compare all GDPR with a privacy law at the federal level in the US. We will see. That's maybe great. A possible evolution. But again, for the moment, I'm very proud that it was possible to have such a kind of negotiation and to conclude such a kind of agreement. Now we have a lot of things to do in the next month, I said, on both sides, to conclude maybe before the summer.
Thank you. And Europe has been a leader on privacy legislation. The U.S. can learn a lot by watching Europe, and it is our strong hope that we could get a federal privacy law in the U.S. as well. Thank you for walking through the importance of this and the work that's gone into it. I just want to ask one quick question before we let you go, and that is, you mentioned you're hearing good feedback from the member states as this works its way through the process, but of course it has to go through Parliament, through the member state process, through the adequacy review process, through the European Data Protection Board. Just as a general matter, are you sensing optimism among all the bodies that are reviewing it that this work can get done and that the importance of concluding this agreement and putting it into force is well understood?
I said I've had a first official discussion with the EDPB to present the new framework. I've had, of course, many informal contacts with members of the Parliament or members of the different governments in Europe. I will go next week to the Libe committee, so in the European Parliament. But the first reaction is at least the recognition that there is a real change. It's not just an amendment to the Privacy Shield. It's something new. That is very clear. The second element that I've discussed already, certainly with the DDPB, is that it's important to explain the situation in the US. To give an example, we have in the US an independent body in charge of the oversight of the intelligence community. But it's not now in Europe. It's not evident to explain that. So I've said, why not to invite maybe to see the DPAs or to see the member states, the people in charge of that in the so-called P Club, so the Privacy, Civil Liberty body, yes, if I'm correct, to see how it's possible to organize a real oversight on the intelligence community. And in the executive order and the implementing act, we are going further with new competence for such an independent body, also in the way to install the review court, so to give a real independence to the review court. So that's the second element we need to explain better. And third, of course, there's a real understanding that we have like-minded partners. And you know that also in the OECD, we are in discussions now to try to have a framework about the access of intelligence services to personal data. Of course, not exactly with the same regulation again, but the same concerns. And it's very important that we have the possibility to explain that with the like-minded partners, it must be possible to find an agreement. So we will see. Of course, we will have to defend our agreement to go to an adequacy decision with the data protection authorities, with the Parliament, with the member states. But I'm quite confident that at least it's possible to explain again that it's totally different from the Privacy Shield, and we have enhanced the level of the rules, the safeguards for the access of intelligence agencies to the personal data and for the direct access to a redress for the individuals coming from Europe.
It is fully responsive to all of the concerns raised by the European Court of Justice, and as you noted, it is a brand new regime. It is in force in law in the United States, and the work here will proceed apace, and we are grateful for your efforts and those of your colleagues in making this a reality. And I'll ask everyone in the audience to join me in thanking Commissioner Didier Reynders for his time today.
Pleasure.
Thank you.
Bye-bye.
Thank you very much.
Bye-bye.
Thank you. So we'll have an opportunity to hear reaction from the individual member state, the Commission, and industry representatives in just a moment. And as we prepare to do that, we want to ask for the thoughts of our audience on all of the work that have happened, that is happening, and will continue to happen here. So we're going to take a look at a poll, our first poll question of the day that comes up online. And you can see it there on your screen, a reminder that you can participate in that poll online and in the room. The poll is a question about your opinion about what the greatest benefit of the data privacy framework is. So as a refresher, our in-person audience, connect to Slido with the QR code. If you're online, please answer in the Slido chat to the right of your screen. So poll question number one, in your opinion, what is the greatest benefit of the data privacy framework? Is it A, ensuring legal certainty, B, safeguarding fundamental rights, C, seamless data transfers, or D, increased trust in the digital economy? So you will have an opportunity to answer that right now in the poll, and we will bring the results to you as they come in. And we will also get ready for our new panel that will be joining us in just a moment as you take a second to look there. A reminder that our panel will be responding to the remarks of Commissioner Reynders, and you have the opportunity to do so as well. Questions are welcome from the live audience and also online. So we have the poll results coming in from our online and in-person audience, and we'll take a look at those results right now on the screen. And we have a clear, well, a pretty clear winner, that's seamless data transfers, reflecting the importance of the EU-U.S. transatlantic data flows to all industries, not just the tech industry. And seamless data transfers seem to be the winner with 43% of the results, but we have safeguarding fundamental rights coming in second place with 33% of the poll. Capturing quite effectively the remarks of Commissioner Reinders and his view that this is important not only for industry but also for fundamental rights protection as well. And now we get to continue our conversation by welcoming both policymakers and industry experts here to the stage to share their insights on cross-border data flows and what we can expect from the data protection framework once implemented here in the EU. Let me start off by introducing our panel to you. I'll start on my immediate left with Ronnie Downs, who is the Director General for Ireland's Department of Enterprise, Trade and Employment's Trade Division, where he works to promote healthy trade and business relationships between Ireland and the rest of the world. Ronnie has also been the Director General of Ireland's Department of Public Expenditure and Reform, the OECD's Deputy Head of Division for Budgeting and Public Expenditures, and the Assistant Data Protection Commissioner for Data Protection Commission Ireland, a very active DPC, I think is safe to say. A warm welcome to you, Ronnie, and welcome. Let me then move on to introduce, seated next to Ronnie is Nana Louise Lind, who is Microsoft's Vice President of European Government Affairs. Nana Louise, welcome. In that role, she's responsible for the company's government affairs and public policy work in Europe and strengthening the external relations between EU institutions and member states. Over 2 decades of experience at Microsoft, so well-versed in the company's perspectives and helping the company be a trusted and constructive partner to the EU institutions and their ambition to drive forward the European digital economy. Welcome, Nana Louise. Let me next introduce on our panel Martinas Barrisis. Did I get that close to right? Perfect. Excellent. Director of Internal Market and Digital Policy at Business Europe, a great partner of ITI's. Martinez is the director in charge of the digital economy and single market governance at Business Europe, which of course is the confederation of European enterprise representing both national trade associations and individual companies from across the EU member states. Martinez worked in the European Parliament and at the Council in his former role as internal market attaché at the Lithuanian permanent representative to the EU. So Martinez, welcome. And last but not least, let me please welcome Ralph Sawyer, who is Deputy Head of Unit, International Data Flows and Protection in the European Commission's DG Just. Ralph, welcome. Ralph, in that role, works on commercial and legal data flows, regulating digital trade agreements like the EU-U.S. Data Privacy Framework. And he's been a key negotiator as this solution to the European Court of Justice case, Schrems II, has moved its way forward. And we're very grateful to him and his colleagues for their hard work in bringing this to the fore. So, Ronnie, I want to start our discussion with you because, of course, as we talked about with Commissioner Reinders, each individual member state has a role to play here in approving the draft adequacy proposal now that the EU and the U.S. has made their decision. There is much more work to do. And I wanted to ask you for the Irish perspective on not only the importance of this decision and the new framework that's been created, but also the questions that you're asking about this as we move forward to approval.
Sure. Well, thanks, Jason. It's good to be here this afternoon. I'm from the Business and Trade Ministry, so I'll start from a trade perspective before getting directly to some of those questions. I mean, Ireland, we're one of the voices, we're one of the member states that has a voice on this, but we're a small, open trading economy. And we've benefited enormously from an open approach to trade, to international trade, over the years, over the decades, indeed. Trade volumes have tripled in the past decade for our country, and that's really helped to underpin, prosperity and well-being in the country, and we want to see that continue. And a growing proportion of those trade volumes in Ireland, but also around Europe and around the world, our digital trade is becoming more and more important. We're conscious that about half of the jobs we have in our country are linked directly or indirectly to that openness to trade. So it's something that we hold dear. And in parallel, we're also ranked quite highly as an advanced digital economy. You're using the European Union's Digital Economy and Society Index. And I think the two go hand in hand, in my view. The world is becoming increasingly interconnected. We're doing more and more business and trade activity is underpinned by digitization and the movement of data across borders. And if we want to see that growth continue and the the good things and the prosperity that come with that, we need to facilitate that in a principled way. And of course, finally on this point, we're conscious in Ireland that digital trade in general brings huge benefits, not just the benefits for consumers and access to goods, from the online platforms, but higher efficiencies, streamlined global value chains, allowing businesses large and small to access global markets. So all of these are good things, and it's against that background that we assess where we are and where we're going with the European framework. Again, on the trade side, before I move to the specific data privacy aspects, we're big supporters in Ireland of all the work that the European Commission is doing to promote free trade agreements, which increasingly have digital aspects and digital provisions to them. It's a very exciting time for international trade. There's a lot of work going on around the world, a lot of work going on in the Indo-Pacific region to forge new ways of doing business digitally, and we want to make sure that Europe, the EU, is at those discussions, is contributing, is helping to influence, helping to shape the new rules-based order for how we can do business together. And of course, there's a lot of aspects to digital trade, but one of the pillars of that is making sure that we can move forward on digital trade in a way that commands the confidence of citizens and businesses and all of the stakeholders. We need to make sure that we can move forward in a way that people can feel safe when they're interacting on online platforms. They're not worrying about what's happening on privacy. They take it for granted that their rights are being protected in the way that we have set these things up. You mentioned in your little resume for me that in an earlier life, it's actually going back a long time now, I was in our data protection office. It's a long time ago. I was in charge, in fact, of the Y2K transition at that stage, so and I'm pleased to say it went very well at the time. But since then, a lot has changed in the data privacy world and the data protection world, and so I'm old enough to remember some of the earlier attempts. We mentioned the Privacy Shield. Before that, there was the Safe Harbor agreement, and they didn't prove to be up to what was required. So we're very hopeful that with the new agreement that's in place now, and with all the hard work, there's been sincere efforts, good faith engagement between Europe and the US to get things right. We're hopeful that will pass muster, and that will enable digital trade to continue and to flourish between us into the future. I think, let's say we're cautiously optimistic. We'll hear what other colleagues have to say, but I think there's been a lot of really good hard work to be done. The gains, if we get this right, for people in Europe and America are huge. So we're anxious to get progress on this and to come up with a lasting, sustainable agreement that people can have confidence in, and that can command the confidence of businesses and citizens.
Terrific. Well, we look forward to working forward on that, and you're absolutely right. This is vitally important to industry and to citizens and to governments to get this right. And Nana Louise, I wanted to ask you for Microsoft's perspective on this as a globally operating company. I mentioned in my opening remarks the vital importance of the U.S.-EU relationship in general, shared values, democratic values, a shared business relationship. It's also borne out in the numbers, $7.1 trillion in trade between the U.S. and the EU that's implicated by this Privacy Shield replacement regime. How important do you think, and does Microsoft think, that success in this data privacy framework is for the transatlantic relationship, and what does it mean about the importance of the U.S.-EU relationship that we're making such good progress here?
Yeah, you're absolutely right. This is crucial for all our customers that they can rely on this agreement. I think it's also a recognition by the US of the importance of the concern, the privacy concern of the EU, that there's a recognition there that this is a real concern. And as you said yourself, demonstrates the willingness to preserve some of the joint values that we share. I think one area that we have not talked so much about is that it's also very important for our security, that we can have, data flow. It's important for EU-NATO collaboration, and therefore we're also very happy about this new declaration that NATO and EU will work together on digital issues. I think moving forward, this hints also to the need for even more close transatlantic collaboration. I think we saw in Ukraine how important it is when we work together and what we can achieve, that we really need each other to tackle some of the bigger issues in the world. And we maybe the last thing to mention, we heard that there will be a relaunch of the negotiation also for an agreement on lawful access to cloud stored data. This is something that we think is very important as well.
Martinez, we've talked about the technology industry perspective, and Nana Luis has shared Microsoft's perspective from the technology industry, and obviously ITI is a tech trade association, so we're very focused on that. Business Europe, where you come from, is a much broader association in that you represent European businesses from across, quite literally, every industry segment. Can you share with us your perspective from Business Europe on why this is not just a tech industry issue? It sounds like a tech industry issue, the flow of data, but it's really much broader than that and has much wider economic implications for European businesses. Would welcome your perspective on that.
Thank you, Jason. And you said half of it already. Indeed, it is about businesses at large. And I represent Business Europe, that represents companies of all sizes, all sectors, and covers basically all Europe. We are the association of 40 member federations from 35 countries that cover the map of Europe. And it was really the call of our members, and a very strong one, that, hey, we need a stable framework for international data flows with the US. And the US and EU data flows for our companies, they bring a lot of opportunities, of course, a lot of efficiencies. And also that affects, I would say, even every enterprise that has something to do with the United States trading partners. We can take, whatever example, we can take the renewable energy sources, for example, how solar energy is used in smart houses and what the follow-up services are related to that. We can take an example of medical tests, how they are run and the data processed and so on. I mean, really, it also concerns SMEs, which is also very important, who use a lot of relationships with the US partners. So that really affects businesses at large. That really affects more than the tech sector alone. And that is why we are quite outspoken about the necessity of a stable framework for the data flows across the Atlantic. We also say that we need a very strong balance in what we do in Europe with what we do with our trusted trade partners, and that's important, trusted trade partners. And of course, we consider US being one of those. So in Europe, within Europe, we speak about the data flows as important as we need a fifth freedom of movement within the single market. At the same time, we say we need also the freedom of movement of data with our trusted trading partners like the US. So this is really very important for our members. What else? Of course, we never leave the trust angle unattended. So trust in data economy, of course, starts with the trust of consumer with, in what is happening with his or her data. So, of course, we need a framework on which the Commission now is following up after the executive order of our Biden administration. So we do support the process, but of course we need also a result. And the result for us, it's about the stable legal framework that businesses can trust in. Standard contractual clauses were mentioned today. They are not sufficient to do business across the Atlantic. And the broader context that we always put all this debate into is that about the three pillars: values of the Western democracies, economic resilience. Europe likes speaking about resilience these days. We think the international data flows with trusted trading partners is also about economic resilience on both sides of the Atlantic. That is why we are so confident in speaking up in support of the future framework, which we'll hope will be stable.
And which we hope as well. And Rolf is here to tell us about how this is going to come to fruition. So Commissioner Reinders talked in great detail about, I think, a very important point, which this is not an update to Privacy Shield. This is a complete replacement. This is a brand new regime. This is a new law in the United States that establishes a new administrative law court, establishes processes and procedures for EU citizens to be able to seek redress where they wouldn't have otherwise been able to in U.S. courts. It establishes rules for the U.S. intelligence community on what it can and cannot do in using that data. So a completely new regime. So Rolf, I wanted to ask you to help us understand how the adequacy review process plays out here for reviewing this new system that's been established. We know certainly that the EU and the U.S. in principle have agreed to this because President Biden and President von der Leyen announced it jointly. But there's a lot of work that needs to be done to finalize the process, and you're here to help us understand how that works from here. I'll ask you to confirm or deny the prediction of July or August that Commissioner Reinders made, but more importantly, to help us understand what happens from here and how the adequacy review process works.
So, well, first of all, thanks for inviting me. Maybe it's good to start, first of all, with briefly at least explaining what adequacy is, because sometimes there's a misunderstanding perhaps about that, because sometimes we hear international agreement and things like this. So it is ultimately a decision by the European Commission, my institution, that is declaratory in the sense it's a finding that a third country ensures a level of protection that, as the Court of Justice has interpreted, is essentially equivalent in level of protection to the one guaranteed in the European Union. The reason for that being that it's the most comprehensive transfer tool that we have. It allows the free flow of data between the European Union and a third country. Our rules require always that there are certain safeguards in place for such transfers. We facilitate them, but we also seek to ensure that there's a certain continuity of protection. An adequacy finding can achieve this by establishing that a third country is very similar in the protections to ours, and therefore we can, in a way, treat data transfers as if they would to the third country as if they would happen within the European Union. So that's the idea. That's why the standard is also relatively high. We have other transfer tools which are less demanding in a way. The Court of Justice has interpreted this as essential equivalence, and the European Data Protection Board has established criteria what that means, so core elements that we need to find. Originally, this was focused on the commercial side, so to speak. So what are the safeguards ensured by companies? That's actually should be the core of such an assessment, because that's where the data goes to. But then, and that was the novelty in the first Schrems judgment, and then it was further clarified in the second. We learned, in a way, from that process that, well, we also have to look at to what extent can companies actually do that, and to what extent could there be interference, and I'm not meaning this in a negative sense, but there could be, for example, access by public authorities that would prevent companies from protecting the data because they would, for instance, have to give it to the government for legitimate purposes. But our task, as the court said, is then also to check that element. So the continuity of protection goes a bit further than just to the initial recipient, which is the company. So that's how we got to having to look at all this. We're not the only ones, I think, that are concerned about government access. I think that's a more and more a global concern. You know, things like the concept of data free flow with trust, I think, is more and more also about looking at what are the rules, limitations, and safeguards for government access. That's why we had the OECD process on principles for government access to data, also from the same angle of how to ensure trust. So that's why we have, and following Schrems too, we had to focus on this particular area, and that's where the US law that has been created, the executive order and the Attorney General come into play. We have on that basis already drafted a decision, so now I come to the process, if you wish. We have already a draft decision which builds on the commercial side very much on what was already there, because there is a lot of continuity when it comes to the rules for companies. But then, as you say, we have a brand new sort of regime to look at when it comes to government access. We have done that. The next step is then always that we go with that draft decision to the data protection authorities. That's foreseen in our rules in the GDPR for an opinion, which is very important. That opinion, it's not binding, but it's of course very important. It's very important input for us and also for other stakeholders, because the next step then is going to the member states. We have a certain procedure where we discuss with member state experts the draft decision in the light of the opinion. So that process really only starts once the opinion from the data protection authorities is there. And then we need at the end the green light from the member states. So they have to vote at some point on the draft decision. We don't need unanimity, but we aim for unanimity. We want that all the member states support this and that we have convinced them. And that might require that we do some further explanations, react to certain points that maybe the European Data Protection Board has raised, to create that level of assurance and confidence on the side of the member states to vote positively, which we of course hope. And then we can proceed to adoption by the College of the Commission. The Commissioner also mentioned, of course, the right of the Parliament to exercise its scrutiny. So, and as the Commissioner said, and I will, of course, would never, in any event, contradict him, but he's also simply right. It's a process where you cannot really say with certainty how long it takes. There are several institutional actors here. We are only one of them. Judging from experience, including the Privacy Shield, we usually count that, I mean, it takes at least 6 months from sending the draft decision to the European Data Protection Board to adoption. And then, of course, there are more sensitive decisions, draft decisions than others. So this is one where certainly stakeholders will look at very closely. So that could mean that we need a bit more time, for instance, with the member states, more meetings in which we discuss these things. But yeah, I would hope and expect that we can adopt this by July, June, July. I think that's what we all aim for, and not just because we want to go on holidays in August. But that's usually what it takes.
It helps.
And plus, we are convinced of what we have proposed. So it has been said now many times that this is very different. It's also in many ways unique. It's also unique that we have discussed this at this level of detail with a foreign government, or rather the other way around, that a foreign government was ready to discuss this with us. So I think, I hope this will be recognized, will be recognized by our data protection authorities. And I must say the first meetings have been rather positive in the sense that one can feel that they see not just the effort, but also that there's an outcome. And so we hope that this will continue. The same with the Parliament. There will be meetings with Parliament, of course, also to debrief them at Commissioner level, at technical level. So there's a lot of work. That's also what the Commissioner said. Of course, explaining. It's a long technical decision with many details and they need to be explained, and that's not always easy, but yeah, we're quite confident. And then what comes after, we will see. I don't want to spoil it, but I mean, there are some stakeholders have announced that they might challenge it. That's, of course, always a possibility, and we should not be worried about this. There's no problem with the Schrems III judgment if it's a positive judgment, and that's right. And that's what we aim for.
That's right. And of course, Mr. Schrems announced that he was going to sue before the framework had even been put in place. So he obviously didn't care about what the actual facts were before he made that announcement. The famous "lipstick on a pig" quote, when we didn't yet know what the pig looked like. thank you for that. It's very helpful, and of course, your optimism about the timeline is refreshing to hear, and we will hope in that. Of course, Ronnie, I want to come back to you to drill down on that last step that Rolf talked about, which was the member states, and ask either from the Irish perspective or what you're hearing from your counterparts in other EU member states about what they're looking for, what questions they might have, and how you see the process of the member state component of this playing out along the timelines that we've been talking about.
Well, sure, Jason. Obviously, I can't I can't look into the crystal ball too much about what other independent member states will do, but my sense is that there's a certain commonality of position across a lot of member states, that there's there's goodwill. We all want to see an agreement that's durable, that's sustainable, that's grounded in the values that we both share, and that citizens on both sides of the Atlantic can repose some trust and confidence in. We respect, obviously in Ireland, and I think in other member states too, there's a lot of value placed on the principles that underlie the data protection and data privacy rules, and we want to see those respected and upheld. And obviously the Schrems II judgment, as we've just heard, pointed to certain areas that needed more attention, and there has been, certainly from all that we have seen, there has been a good faith, intensive engagement on addressing those to hopefully get us where we need to get to. I think we're going to have to see exactly what it is that the Commission comes back to us with. We're going to have to talk to our colleagues and our peers about whether we have indeed, as we hope, reached a position that squares away and balances all of these issues, and we'll make a judgment in due course. You know what way we want things to go, but we'll handle this straight, and we'll handle it in concert with our colleagues. And I will just make the point, if I may, that those EU citizens who have exercised their right to take legal challenges against the provisions and the measures that have been in place up to now. One could have different views from a business or from a data privacy perspective, but one could argue that those citizens are perhaps doing us all a favour by accelerating us along the path to where we need to be, which is a stable, sustainable, durable framework which can withstand the tests and can pass the tests that it needs to pass so that we can all reap the benefits of trade and digital trade and data flows into the future.
And Nana Louise, I want to ask you to be our voice of, I don't want to say voice of doom, but voice of reality. And I'll ask you in just a second to address what happens if this doesn't move forward and we don't get this replacement. But a reminder to our audience that you have the opportunity to engage directly with our panelists by entering your question into the chat on the right of your screen if you're online, or if here in the room. Please take advantage of the QR code that will link you to Slido and allow you to ask a question of our panelists as well. We have some great questions coming in that I hope to have the opportunity to get to. But Nana Louise, Microsoft has really done a terrific job since the Schrems II decision was issued in helping us all understand what the implications for business are if this replacement regime is not put in place. There was the idea initially that standard contractual clauses would save us all, and that worked for a period of time. But I wonder if you can help us understand at a layman's level what is at risk, really, for businesses here in Europe in particular, if this regime is not put in place in a timely manner.
I think legal uncertainty is never a good thing. And we saw that also on the poll. There was a concern from many people. When we had the decision from the court, it left more than 5,000 companies in a situation where they relied on that privacy shield for their EU data transfers, and had to scramble to find other solutions. And we know from our customers that they did also pause projects other places in the world, not only in the EU. And yes, we tried many different ways to help our customers and allow data flows anyway. We followed the guidance also of the Data Protection Board. But yeah, we are like so grateful for the work that has been done to land this agreement. We hope it will restore trust and legal certainty, provide legal certainty to businesses. I think there's also the security aspect that I mentioned earlier that is very much dependent on this going in the right direction. And I think it's true, it will be challenged, but we are also confident it will stand the test. So at least we hope so. But just wanted to say thank you again for the tremendous work that has been going on. It's very, very, very helpful.
And very important as well.
Yes.
So I would echo that as well. Martinez, you're watching obviously this, and I want to get your perspective on the Business Europe reaction to the decision, the adequacy decision that's going to be moving forward, and the solution that's been developed. But I also wanted to ask you for your thoughts on other data-related matters that are under discussion here in the EU, the Data Act in particular, and the potential impact on the use of non-personal data there. So as we move this piece forward, please offer your thoughts on the solution that's been developed and Business Europe's reaction to there, but also what else should we be watching as far as data regulatory issues in the Data Act and elsewhere?
Thanks a lot. You caught me on this now, because that's really a much broader topic and a crucial one, because this is about where geopolitically even Europe places itself with the data economy. So thanks for the question. I'll come to that broader one, but let's start maybe first with the draft adequacy decision. We are looking into it. Well, 3 points maybe. And I would like first to start what the Commissioner mentioned, that we do have to acknowledge the step that the US administration made. I mean, this is not insignificant, what we see, and especially in the given context. So we have to acknowledge what the Biden administration made as a step towards Europe, towards European approach in terms of privacy. Because at first glimpse, it might sound a bit technical, it's about the personal data flows, I mean, they did something and so on. It's far from technical. So that must be acknowledged as the first thing. The second thing, we of course would like to comment what the Commission has been doing with all the patience that it requires and with all the necessary engagement with the partners across the seas. What we see as an important thing is that the Commission makes the validity of this adequacy agreement conditional upon implementation. So there will be a close monitoring in terms of how actually the executive order is implemented in the US. So that is an important thing. And that, of course, as we see it, brings about more trust. So we very much hope, once again, and my third point, I come back to the same message. We very much hope that the pillars of economic welfare, economic resilience, then stability of the legal framework, and Western values will be upheld. And we very much hope that this time we will have a really stable framework that will be approved. We really do not need Harry Potter, in these sensitive issues to go on and on. We don't need Harry Potter series. So that's about the adequacy decision draft. Now, in terms of the data column at large, and by the way, you mentioned Data Act, but it's also about the Artificial Intelligence Act, also about some cyber issues. It's a much broader topic, which is really very crucial these days for Business Europe membership. With the Data Act, shall I put it this way, we understand the objectives, we understand the willingness to give a boost to the data economy, but we do have many more questions than answers for today. And there are some interesting provisions that the business community is not quite happy about. And that also relates to the data transfers of non-personal data. Because there are some provisions, as we interpret those, that if there are no international agreements, that the businesses should take all the possible measures to prevent data transfers across the seas. or to prevent access to such data. For us, it's a real challenge to understand how the public sector transfers basically its function onto the private operators' shoulders to assess the third country laws. You know, whether they are against or in line with the EU or member state legislation. I mean, sorry, this is a matter for the public authorities. And how can you imagine a company being capable of assessing these kind of things? And I'm also having in mind the SMEs, for example. So for us, this is a real challenge. What to do when there is no international agreement? Again, then we are in a limbo. So that is about the Data Act. More questions than answers, unfortunately. We see that it is very difficult to improve the present draft. I will be very honest with you. We are trying to be constructive and to engage in the dialogue because, as I say, these are the times when Europe is putting itself in the global data economy, where we are. And if we cut the things that we need with our main trusted trading partners, I think we will forget about trying to compete with some of the big economic powers in a matter of 10 days. So we should avoid that by all means.
Thanks very much for that perspective as well. Rolf, before we get to questions from the audience, I want to ask you to leave us with your kind of top 3 most important components of this regime. We've heard from Commissioner Reinders that this is brand new. This is the establishment of an entirely new system of justice in the United States for EU citizens. What are the 3 most important things from your perspective, because you helped draft this decision? What are the 3 most important things for us all to remember as we endeavor collectively to help move this forward?
I think I have different ways to be lame here. I mean, one thing would be to say all of the elements of the decision are important because all the findings are necessary for in the end having the adequacy finding, which is, as I said, this declaratory finding, which then allows the free flow of data. The other way of being lame is to more or less echo what the Commissioner said and also, of course, focus on what the judgment was all about, because obviously those are the important elements that we had to focus on. So I'm not going to talk about the commercial side. And that's actually a bit strange, because we should not forget that this is first of all a transfer arrangement that seeks to ensure safeguards by the companies that they receive it. But nevertheless, the discussion has focused and has shifted and is now concentrated on this second aspect. So government access for national security, something which is a very delicate area and yet something that we have to look into. And I, by the way, share the view that it's something that's not really suited for companies to do. So I also think companies need help in this, and an adequacy finding is, of course, one of these instruments. So if I then look basically at what the judgment was about, I mean, that reflects then what are the most important elements, I think, in the decision. So that's on the one hand, the limitations and safeguards around government access in the area of national security, and in particular, I would say, the enshrining the principles of necessity and proportionality in the executive order, and not just by name, because that's one criticism that we have already heard. What does it mean? Okay, fine, the US has now sort of accepted to use these words to please the Europeans, but that doesn't mean much. I think that's completely wrong. The executive order does much more than that. It just doesn't have like one line where it says governing access in this area has to comply with principles of necessity and proportionality. No, it explains what these principles mean in general terms and through specific requirements for different types of access, for instance, targeted access, what is called bulk collection, and which is very often misrepresented as mass surveillance, which is a different thing. So it explains what that means and what are the specific safeguards that sort of operationalize these principles. So I think that's a very important aspect, and those are binding obligations on intelligence agencies. They are enforceable, as we've heard, and that brings me then to the second element. And they come on top of other safeguards which already existed. We should also not forget that. We had already in the Privacy Shield decision, of course, pointed to many other safeguards and guarantees that exist in US law. This executive order comes on top of that. So that's the first aspect, I would say. The second aspect, obviously, then redress, which is of course very important. And again, the Commissioner explained that we had to find a solution which conforms, ensures that we comply with the requirements of the Court of Justice, so that we can adopt a decision which stands the test of time and the scrutiny of the court if ever this is challenged again. But at the same time, we had to find a solution that fits within the US legal system. And I think that's the second remarkable part, that we have found a solution. Yes, it's an administrative tribunal. It's a tribunal which is sort of located within the executive, but it's an independent tribunal with all kinds of guarantees for the independence of the judges that will take the decisions, that has investigatory powers, full investigatory powers to access all information necessary to review a complaint and adjudicate on it, and enforcement powers to take decisions which are binding and can go from terminating a collection to deleting the data that was unlawfully collected. And there's a special representative for the individual that takes care of the interest of the individual in a setting where the individual might not be able to be present because it's about national security matters, and therefore there's a confidentiality need. So that's the second aspect, obviously, and importantly, and that's sort of links back to what I said at the beginning. It had to fit in the US system. The US system, by the way, not so different than from our system, has admissibility requirements when you want to go to court, to the judiciary, which means you have to show that you are individually concerned, which is very difficult in a situation where you cannot show, because you should not know, perhaps, that you have been subject to surveillance. Here we have created a tribunal where you don't have these requirements to show that you have been subject to surveillance. You can simply go there. So that's something which is a second very important element. And then the third one, which is linked to that, to both of the two former elements, which is the oversight that's exercised, not just by our evaluation or review process that we will have, and where we will meet with the US colleagues in regular intervals, but in the US system, and the Commissioner mentioned the Privacy and Civil Liberties Oversight Board, an independent body that will play a crucial role in this whole system of assessing, for instance, the implementing rules that will have to be put in place, and assessing the functioning of this Data Protection Review Court and how it functions, and that it functions well. And it will be able to have much more information on how it actually functions than could be given to a third country or us as a regional, a foreign international organization. So that's a very important complementary part to have this role of the P Club, as it's called, and which has a very high reputation, I think, and has in the past published very important reports that have led to major changes also in US law, US intelligence law. So it has a very important role to play, and we're very happy that it's sort of built into that system.
Terrific overview, and you've actually anticipated and answered many of the questions that came in from the audience, Rolf, so well done to you for that. The questions from William and Timothy and David all focused on your optimism about whether or not this will withstand scrutiny, and why this is moving forward in parallel with U.S. implementation of their own requirements from the executive order. You've discussed that, and whether the executive order is concrete enough to answer the European Court of Justice question about the need for definitions around U.S. security and definition around when it's okay to use European data and information. So you've, I think, addressed all of those. And it sounds like, I don't want to put words in your mouth, but it sounds like you're optimistic that this has addressed the concerns raised by the European Court of Justice and will withstand further judicial scrutiny.
We wouldn't have otherwise come out with this draft decision. People would say, but you did so last time and it was annulled. But okay, we're doing this following a judgment which gave very clear directions, and that's very different, by the way, from the first time that we had the annulment. I mean, there we had a more general judgment which assessed the decision, which didn't have any assessment of this government access part, because it didn't have to, because it was adopted in 2000 when nobody thought about that this was part of the assessment. So we are in a very different situation in terms of sort of the mandate from our highest court, and so we, of course, we had to be also much more careful, and yes, I'm optimistic that we have lived up to that challenge.
Excellent, excellent. Well, I appreciate that perspective, and obviously we'll hear the U.S. perspective in just a few moments from Ambassador Gittenstein. I would ask all of us here in the live audience to join me in thanking our panel for a truly robust, informative, and engaging discussion. And the sense of optimism about the decision that will be made sometime before summer is palpable. But we want to ask all in our audience to share with us as well their view on the importance of the data privacy framework. So we'll put up our second poll question, and then as soon as we have our poll results in, I'll introduce Ambassador Gittenstein to all of you, and we look forward to his remarks as well. The question from the panel is, what does the data privacy framework mean for EU-US relations? And in this question, you have 4 options to vote on. 1, closer alignment on digital regulation, which you've heard a lot about, both as to pending and future regulatory issues before the EU. 2 is more business opportunities for EU and US economic operators. 3, enhanced protection of democratic values, those shared values between the EU and the US. And 4, boosting innovation in the EU and US. So those are your 4 options. A reminder that you can participate in the poll online by going to the window on the right-hand side of your online screen. If you're in the room with us live, as so many are, you can use the QR code and participate in Slido and answer the questions there as well. As we prepare our poll responses, which are coming in real time, thanks to the magic of technology, you can see that most of our poll answers have been as to selection 2, more business opportunities for EU and US economic operators. $7.1 trillion in global trade happening between the EU and the US implicated by this. 16 million jobs created in both the EU and the US as a result of robust digital data flows. So terrific there. We appreciate everyone's participation in that poll. It is now my great pleasure to move forward in our conversation by introducing to you our final speaker for the day, His Excellency, Mark Gittenstein, who is Ambassador of the United States of America to the European Union. Ambassador, I would get up and greet you in person, but I am literally tethered to my chair by wires. So if I were to stand up, I would collapse the stage. So I will give you a greeting from afar with our thanks on behalf of ITI for your being here today and for your service here in Brussels. Ambassador Mark Gittenstein spent the beginning of his career actually working in a different branch of government, the United States Senate, on the Judiciary and Intelligence Committees, working for a then well-known, but perhaps not as well-known as he is today, senator from the United States state of Delaware by the name of Joe Biden. He worked for then Senator Biden for 13 years. He then co-chaired Senator Biden's transition to the vice presidency in the Obama-Biden administration in 2008, and also helped set up his transition to the presidency of the United States in 2020. He's also spent most of the past decade in Central and Eastern Europe, acting as ambassador or as counsel to NGOs, commercial clients focused on preserving and fortifying democracy. Ambassador Gittenstein, it is a true pleasure to have you with us here today to share your perspective and the United States government's perspective on the importance of the transatlantic relationship between the U.S. and the EU. And I will welcome you to the podium and invite you to share your remarks with us. Thank you.
Well, thank you, Jason, and thank you, panelists. That was a very interesting panel. I must say I've been working on this issue long and hard pretty much the whole year that I've been here. I learned a lot today from the panel, which I don't know if that's good news or bad news, but it's great to be here, and it's a pleasure to celebrate the progress that we have made in creating the EU-U.S. Data Privacy Framework. One thing Jason didn't mention in my biography is actually the way I met Joe Biden was I had been working, for those of you who know the intelligence community and the history of its regulation in the United States, on something called the Church Committee, which was created in 1974, I believe. I actually was on the staff of that committee, and I got to know Biden after I left that committee, and I was thinking of going into private practice, and he enticed me into coming back to work for him as a staff member of the Permanent Intelligence Committee, which was working then on the first effort to actually regulate the intelligence community and its surveillance of American citizens. And that was called the Foreign Intelligence Surveillance Act, which many of you have heard about. But then Senator Biden and I were instrumental in drafting that bill and dealt with many of these same issues. So when it came time to present the final description of the arrangement that he and President von der Leyen and he would announce that day when we were prepping the president, I discussed with the president that this is in a sense a bookend 40 years later to the work we started in 1976. In which we were regulating electronic surveillance and signals intelligence, many of the same issues that the Schrems II decision forced the United States to confront, and that we should both be proud of it, and he was. I think he recognized the point that Jason and Ralph and others have been making, which is this is a huge change in U.S. law. And I hope people in Europe, I particularly hope the data privacy boards, and in particular the court, will recognize how significant this change is in the way we regulate our own intelligence community on data involving not just American citizens, but European citizens. I might say that in 1976, when Senator Biden and I were working on this, we tried to get coverage of non-U.S. citizens in the legislation. We failed, but now, in effect, we've accomplished that because of what the EU has done. And I give the EU credit and the court credit for forcing us to face the importance of this issue. I think it's important to understand, I think we've gone over a lot of it today, but just so you hear it coming from my mouth, that this puts us in the first element of the framework is we are putting significant restraints on our intelligence agencies themselves. And we've created an independent redress body which did not exist before the executive order that was issued pursuant to our understanding with DG Just and the Commission generally, and that all investigative complaints that violate the standards set out in the executive order are now subject to an administrative agency, but one that is subject to, in effect, the Administrative Procedures Act, which those of you who know a little bit about American law, is a generic law that requires that any agency that commits to undertake certain administrative responsibilities is subject to the Act and to our Constitution independent of this arrangement. And I think it's probably the first time, other than the Foreign Surveillance Act, where we've taken signals intelligence, which is a very sensitive area of intelligence, and made it subject to restraint as it relates to foreign citizens. We worked diligently on this issue long before I got here. I didn't get here till January of last year. The Biden administration and the European Commission were hard at work on this issue before I got here. And we were attempting to strike the appropriate balance between civil liberties on the one hand, national security on the other, and the flow of data to support a $7 trillion trade arrangement between the United States and Europe at the same time. I think we struck the right balance. I think, obviously it's not my decision to make as to whether the Schrems has been complied with. I'm very happy with what I've seen in the draft adequacy finding, but in the end, as we all know, this will be up to the European Court. I think what's the important lesson I took from this is that as a U.S. ambassador, and I'm facing this now and a number of other legal and trade-related issues, which you all know, probably heard a lot about, is that when we engage in discussions on these two huge democratic systems, the European Commission and European Union on the one hand, the United States on the other, they are both federated democratic systems that attempt to support the same values, transparency, rule of law, democratic values, that because of our traditions, we deal with them slightly differently. And to the extent when we get into negotiations or discussions about differences, as we were doing with Schrems, as we are now doing with a number of trade disputes, it's important to understand that the values we're trying to protect are actually more similar than they are different. And that to the extent you can move the debate to those values and protecting those values and recognizing that we have cultural and legal and historic differences that go back hundreds of years, that if we don't focus on the differences, but we focus on what we hold in common, we can reach an agreement, which is what we did in this case, at least for now. I'm very optimistic about where this will end up, but I think it's important to recognize that, as Rolf points out, we're not done yet, and as the Commissioner pointed out, we're not done yet. I think we've laid a very firm foundation to get the right result, and I'm anxious to see what happens this summer and what will happen after that, which will clearly be a court decision. I am certain that if we use this approach to resolving our differences in this particular area, which is technology, privacy, national security, we can reach the same consensus in all the other areas we're working on, because I can tell you, having spoken to the President about this, there is no issue that concerns him more than reaching a unity of approach on both sides of the Atlantic on all the problems we face, not simply Ukraine and data, but climate change and all the human rights issues that we face and economic issues we face all over the world. So I would thank all of those on the panel, and especially those who worked in the Commission on this, and the technology community. I'd particularly point out Microsoft has been extremely helpful to us in understanding the implications of these decisions. And so I look forward to working with all of you in the future and be happy to answer questions if you would like.
Thank you so much, Ambassador, for your remarks. And I do have, thank you. I do have one question to ask you before we let you get back to the important work of emphasizing the shared values of the U.S. and the EU, which you stated so eloquently. And this, I think, is a great example of the unwavering relationship between the U.S. and the EU. you offered a hearteningly optimistic view that this time around the work to put a framework, a data privacy framework in place will survive scrutiny. And I say this time around because, of course, the last 2 times it hasn't. You emphasized and you made reference to Commissioner Reinder's comment that this is a very different regime that has been put in place, and the President's executive order establishing really a brand new administrative process, a new administrative review process, and a new quasi-judicial system within the intelligence community is brand new. I wanted to ask you why it is you're optimistic that this time around the work has been done to satisfy the concerns that the European Court of Justice has twice before expressed, and why we should share your optimism that this time around the result will be different.
I'm going to begin answering this question with a story, okay? People accuse me of using stories too much, but it's the easiest way for me to explain, and hopefully you'll understand where I'm coming from on this. I got here in March. Within a week, I was in the middle of this dispute. I got on all of these calls with American lawyers at the intelligence community. Fortunately, I had one phenomenal lawyer, Amy, who's sitting in the audience with me, helping guide me through this. But the lawyers I kept hearing, especially from the intelligence agencies, the Justice Department, started huge debates over what the Schrems decision meant and didn't mean. I said, after listening to 2 days of this, I said, stop, okay? I don't want to hear another American lawyer explaining to me European law, and I don't want to hear a bunch of European lawyers explain to me how our Constitution works. Let's stick to our knitting, as we say. You tell me what we can do under our system, and I'm going to listen to the Rolfs of the world and the Didier Rangers of the world about what the European law means. And let's see if we can reach common ground. So I hesitate to say, when I say I'm optimistic, I'm not saying me as an American lawyer, and I have a little experience as an American lawyer. I'm giving my opinion about what the European Court of Justice will do. I actually don't know the answer to that question. But I do trust the Rolfs of the world and the Didier Rangers of the world telling me what they think the court can do. And if we, and you know, the key to success here in transatlantic relationship is listening, and listening to both sides. And it's not being arrogant on our side about what we think you should be doing and vice versa. To the extent we do that, the consensus seems to be from the European lawyers that this will work. And I take their word for it. And I do know that we pushed the envelope as far as we could under the American system to reach the goals of the court. Now, if the court listens to us and listens to the adequacy findings and listens to the boards when they look at this and recognize this is as far as we can go, there actually isn't an alternative. For the court to say, okay, we want you to do more, well, that means you just are not interested in seeing this work, because we can't, there's really literally very little more we can do. So, I mean, I could get into the details. I think it would be better. I think Amy would be more comfortable if I didn't. So that's why I'm optimistic, because I think we both listened to each other. Each of us went as far as we could go, which is, you know, the hallmark of a good negotiation. So, you know, I am an optimist by nature, but I do think it's going to work.
Well, we share your optimism and we appreciate your perspective. Please join me in thanking Ambassador Mark Gittenstein for his remarks. And thank you to everyone on the panel and all of our speakers. Thanks to Commissioner Reinders, and thanks to all of you in our audience here in the room in Brussels and around the world online for participating today. You know, the digital landscape is constantly evolving, as we've heard today. It brings forward new and innovative technologies, and we're pleased to have the opportunity to discuss how the way in which we live our lives and work and communicate together can be improved by innovation. But of course, the new challenges that this brings in the policy arena are also worth discussing, and we are going to work together industry, public and private partnership to create the kind of balanced, fit-for-purpose legislation and regulatory decisions that make all lives better through technology. It's an increasingly complex geopolitical context that we operate in, but discussions like this today really help us move forward with the right digital policies. ITI, as the trade association of the technology industry, we look very much forward to seeing what the future holds and how we can continue to rely on the close transatlantic relationship to advance technology on behalf of citizens and businesses in the US and the EU. And we will work collaboratively together to move the digital privacy framework forward. So this marks the event end for us today with our thanks to all our speakers and all our participants. You can continue the conversation online using the hashtag #dataflows. On behalf of all of us at ITI, thank you for joining us. We look forward to seeing you again soon. For those online and for those in the room, please join us for a reception immediately following our discussion here in Brussels. Have a good day and look forward to seeing you again soon. Thank you.